Okay. Hi guys. I want to find out, are we on Unit 6 or have we moved on from Unit 6? Please rectify me if I am incorrect.
We're doing Unit 6, Leandre.
Thank you. Okay, where do you guys want to start? Oh, this thing's going to drive me mad. Just want to quickly see something. Okay. Did you all get the focus areas? I think we must go through that as well as our study guide. But I see on the focus areas there's some of the pages that are marked, and then there is some of the cases we don't have to know. Okay. So do we start with the things we're not supposed to know, or should we just start at the beginning?
Can you just please start at the beginning?
Do you want me to start at the beginning? Okay. All right. So our topic today is where to find the law. Okay. So the question is, where do we find the law? What? Yes, Tobile. Tobile.
Hi, ma'am.
Hi.
Hi, I was wondering if you could share the focus areas for chapter 6.
Okay.
Yes, please reshare them on WhatsApp because I don't think I have them.
Okay, I'll quickly see if I can do that as well. Okay, so I'm just going to start at the first thing, and then we can go to the pages that is said here on the focus areas. Right. They want us to know what the source of law is. And there's a whole court cases and everything on the... Yes, you can ask me a question.
Hi, ma'am.
Hi.
I wanted to ask, are we using the study guide or which book are we exactly using? I'm sorry.
No, it's fine. You may ask. What we are going on is the focus areas that are in the study guide, and then those focus areas are the lessons they have on the my module under ILW. It is there as lessons. So what I do is I just get them from there, and then I do the whole study guide, but then I focus a lot on what they already said are focus areas. Okay. All right. So we have to know what is a source of law. Now, until the page 100, there is just cases, and so I would suggest just read through it because there is a lot. It is about, let's see, from roughly almost 20 pages. So then at the top of page 100, it says, what is a source of law? Now, I want you guys to tell me before I give you the answer. I need you guys to participate. Come on, guys. You want to ask a question? Azande, you can ask. Azande.
Hey, ma'am.
Hi.
You said you were asking a question. What's our sources of law?
Yes, what is the source of law?
In South Africa, sources of law include common law, customary law, international law.
Is there someone who wants to agree with her or disagree?
Ma'am, I disagree. Remember, those are the categories under the sources of law.
Yes.
So we have persuasive, and then we have authoritative source of
Yes.
law.
Okay, Bongani. Sorry, I'm just going down the line. Bongani.
Yes, I do hear you. The sources of law, we need to understand that the South African law is not codified, meaning that it does not exist in one single catalog of law. It exists in different authoritative places which are used as reference for the application of law.
Okay. Rhonda, you have a question?
I just wanted to say what Bongani has just said. That's is to where we get information, where we get to reference. Suppose we need information on where we can find laws. Suppose we want to solve a solution, we want to solve a case. Oh, I wanted to ask, ma'am, can I please ask?
Yes.
Oh, that time you were saying, where can we find the key sources, key areas of study in our study guide? Where?
Okay, now the focus areas.
In our tutorial letters, where can you find them?
They're not in the tutorial letters. When you go to my modules.
Oh, all right. Okay.
Someone's mic is on.
Thank you.
Okay, so it's if you go on your my modules on your app or your laptop app, you go to ILW, and then they will show you down there. There's lessons. Now, what I do is I take them, I copy them, and I paste it, and then I send it on the group, so that not just me can have them, but all of you guys as well. Okay, so it's not in the study guide. I'm only referring to pages in the study guide. Okay. Does that make sense to everyone?
I think so. Thank you.
All right. Okay. So she gave us a good answer. It's the places where law originates from. So for we remember the Roman Dutch law, the African customary law, all those laws. We have to know that they are places that we can reference from. All right. So it's places where we can reference from, and then as we find our references, they will tell you where each of them is. So if you want to know what page in the study guide, it is page 100 at the top with 6.1.1. Okay, then we get.
Can I come in, Leandro?
Yes.
All right.
Please.
Yeah. Good evening.
Hi.
I just wanted to just say that you know, just to maybe add,
Yes.
you know, of course, sources of law is the places where the law originates from. Now, if you look at it, I think Bongani has already explained that we don't have a code, a single code. So what we have is different. Our law is found in different places because of the history of our law. So if you go through it, there is two kinds of sources of law. It's authoritative sources of law, and the second one is, I'm just looking quickly. The second one is the persuasive sources. So it's authoritative sources and persuasive sources. Under authoritative, then we've got our list there. We've got legislation, we've got judicial precedent, we've got common law, custom, and also African customary law. So if there could be a question that says, what sources of law do we have? You have two main sources, authoritative and also persuasive. And then under authoritative, you then have those five, which you can list if you want. Legislation, court decisions, common law, custom, and African customary law. Now, what's interesting there is that you've got to now drill down in terms of what it means to have legislation. What does it mean? Because when the question comes, it could say legislation, it could say acts of parliament, it could say statutes. But I think what we should remember out of everything that we learn here is that the constitution is the primary. It's right at the top of the hierarchy. So every law must align with the constitutional court. If it does not align with the constitutional court, then that law will then be corrected by the constitutional court. And so what follows there then are definitions under all of those things. What does it mean, legislation? What court decision means, and et cetera, et cetera, et cetera. Before I leave you on this one, under legislation, you will see that it's quite long, actually, longer than the other ones, because there's quite a bit that you will need to learn this. So I think that if you can just focus on that, so you know what follows on legislation. I just wanted to say that for now. Thanks.
Thank you. Yeah, if you guys want to find out where we got that and what it is, it's on page 109. It's the feedback of the activity. Okay, there they have a diagram at the bottom of that page. Yeah, so I just want to tell you guys that. All right, so we just spoke about codification, which is on page 100 and 101. Okay, so there is those two are there. I see here's a footnote on page 101. There is a note there that I think we must take into consideration. We must make note of it because it will tell you more or less how the Constitution started. Okay, but we will learn more about the Constitution and the constitutional issues in units 7 to 10. But now that is just how it started and how we got to where we are today. Okay. Zama already touched on the two different kinds of sources of law, which is authoritative or primary sources And then second is persuasive or secondary sources. Okay. They do say study diagram learning in learning unit 6, activity 6.2, activity 6.2, and it's feedback on page 109, and also the note on page 107. That is right at the bottom of page 107. Okay. Anyone want me to repeat that? Just thumbs up, or is there anyone with a question?
Please repeat, ma'am. I just lost you.
Okay. So the codification of law is on page 100 to 101. Okay. Then the two kinds of South African sources of law, which is one, authoritative or primary sources, and secondly is persuasive or secondary sources. You must know activity 6.2 and its feedback on page 109, as well as the note on page 107, right at the bottom. Okay. Okay, can we move on?
Thank you so much.
It's a pleasure. Okay, this Zama also touched on under each of the sources of law. They have different, so it starts on page 101 and goes all the way up to, authoritative goes from 101 to 106. And then on 106 at the bottom, it starts with persuasive sources. There's only 3, so they're not as lengthy as the others. Okay. All right. Yeah, is there someone who has a question about anything until now? Anything you guys might want to know before we start going into? Yes, Rhonda? Rhonda,
Okay. Thank you, guys. My question is on the main, on the authoritative sources.
Yes.
On the list, guys, there's casework. Isn't casework the same as court decisions? What's the difference between the two?
Sorry, you're saying there's case what?
There's case law and there's court cases. There's court decisions. Are these things not the same thing?
It's the same thing.
It's the same thing, ne? Somebody, why did they put them like that?
Remember,
okay.
Remember, these things could be when they ask you questions or when they talk about things, they could say to you, case law. You must know that case law is court decisions. When they talk about, for instance, legislation, you must know that legislation is act of parliament. So you must know all the words, even if they mean the same thing. But you
We
must
can
know.
use them interchangeably.
Exactly.
Oh, perfect. Another question. Thank you so much. What's your name?
Zama,
another question, guys. Still on authoritative sources, we've got custom and we've got African customary in brackets indigenous law. Same applies, ne?
No, that's not the same.
We are talking about two different things: custom and African customary indigenous law.
Yeah, no, those are different. That's why if you look at the book, I just got home now, but if you look at the book, you will see that the other one I think is on point 4. Just quickly sit down here. Just
Of course, there is a difference in when they write them here, but can't we use those two terms interchangeably?
Not in all instances. In some instances you can, but not in all instances.
Okay.
For instance, let's just quickly explain. So custom. Okay, similarities between both of them are that they are unwritten.
Okay.
So custom is made up of written rules, but developed from custom to custom within the community. So these are community-based laws.
Okay, all right.
And it's basically unwritten that goes generation to generation to generation. How it's similar to African customary law or indigenous law is that it is also unwritten. But the difference is that African customary law or indigenous law, some of it has been documented because of case law, because of verdicts. So it then becomes documented as a result.
And I can see here they wrote it in bold letters. Yeah, okay.
Yeah. So that's, you just got to make, of course they look quite similar, and in many instances you could possibly use them interchangeably, but I think that you've got to be able to differentiate.
Thank you, sir.
Okay.
Can someone mute my mic? Thank you. Please.
Okay, you muted. Zama, some of the people are confused and they are not agreeing with what you just said.
Okay, they must correct me. It's fine.
Because they say here at the bottom, no, customary law and indigenous law is the same thing. Why do you guys say it's the same?
Can I answer that, because it's me who asked the question?
Yes.
So the difference is only that the indigenous one is now being used sometimes in the case law. Unlike the first one, which is custom law. Custom law is like in our communities, those norms that we tell each other from generation to generation. Am I making sense?
Yes.
Yeah, that's how I understand from the former speaker.
All right. If we say, okay, sorry. If we say it's the same, before Bongani comes, if we say it's the same, then why would you have 5 bullet points explaining each of them? Because if you read on, let's just go to custom. They say here on page 104, that is under custom. Ne? African customary law also forms part of the broad definition of custom. However, because African customary law has more formal status under the South African law, it then is dealt with separately. So the difference there is that custom does not have a formal status under the South African law, whilst African customary law has a formal status. But people can come in and share different views.
Bongani?
So, in other words, in solving cases, people are now using the the indigenous law. So I think it has got more importance than the custom one. That's my point of view.
Okay, Bongani, you want to ask something or add something?
I've got a contribution to make here. From my understanding, I think customs forms under community laws, regardless of whether the community is African or not. Last time I raised the issue of Muslim laws. We can look into custom in the perspective of the Muslim law, which some aspects may fall outside African customary law. So customs focuses on community laws. And these laws are not written unless the community is African or not. So it's just a community laws, specifically that the laws that apply to that community. Then the
100%.
is open to African under customary law.
100%. I agree.
Okay, you all happy with that? If you're having trouble, we are on page 104 and 105. At the end of 104 is the customs, and then the African customary law is on 105 at the bottom. Okay. But I do agree with both Zama and Bongani. If you guys check on those 2 pages, they are written in dark black letters. So they wouldn't have put it there if it was not important. Okay. So we are there. Anyone else with a question, or you are happy with that? Where do you have trouble with? Because I hope everyone went through the unit so that you can ask lots of questions. So persuasive sources of law is only 3. Okay, so it's only 3. Azande? Okay, Azande says yes. Okay, we lost her. Azande, we can't hear you. I'm going to read yours. Can you hear me?
Can you name those sources of law for me, ma'am?
Okay. Are we starting from authoritative or are we at persuasive? Which one are you at? First or second?
Second.
Okay, so it's the persuasive sources of South African law. There are 3. Other legal systems, foreign law, and the views of modern legal writers. Okay. So what do you say is other legal systems? What would be in that, under that heading, if you hear about other legal systems? Come guys, we are 86 this evening and none of you want to talk to me today?
Ma'am, can you kindly repeat what you said? I didn't hear what you said.
Okay. Persuasive sources of South African law includes other legal systems, foreign law, and the views of modern legal writers. Now, what I want to know is if you hear the term other legal systems, what do you think it is?
Labor
Anyone?
laws,
Yes.
labor laws, is it mercantile law?
What other legal systems do we have? Zanele?
Ma'am,
Yes,
it could be other rules that are used in other countries or any courts. Like considering that the who, for example, ma'am, if in in-
anyone else wants to try while Zanele catches the train of thought?
Can I come in?
Yes.
Other legal systems are really those legal systems that are historically related to ours. So you talk about Roman law. You talk because remember Roman law basically influenced not only us but different other countries. For instance, France, Germany, Netherlands. So those are quite similar to ours. So those legal systems then become quite similar to ours.
Yes. So if we say that, what is foreign law? If we have other legal systems, what can we say is foreign law? I'm going to... Okay, Azande wrote here. Legal systems include legislation, common law, judicial precedent, and customary law, international law, and sometimes foreign law. Okay. Do you agree with that? Okay, Katleho said yes. Bongani?
I've got a different interpretation of this section when it brings foreign law as a source of law. My understanding is that when the components of a foreign law are used as a amicus curiae to help the court reach a certain reasoning that is beyond the prescription of its own laws. We talked about last time in international law. Then we looked into the jurisdiction of the court and we assumed that it would be South African. But just because the matter involves another part, an international part, which uses a different legal system, and by virtue of borrowing certain principles from that system, from that legal system, as amicus curiae, will help the court to reach a certain understanding on the matter.
Okay.
I'm sorry, guys. Can I interrupt, please?
Yes.
Guys, the difference between a foreign law and other legal systems is not clear. Can the former speaker please explain again, please? Thank you.
Sama, Bongi. I'm calling you new names now. Sure. Guys, can you please explain it again?
I'm not sure if my explanation is the one that is given the rise to this question, or is the from the previous speaker. I'm not sure.
She's asking about the foreign law. She's saying that what is the difference between the foreign law and the other legal systems? I think it's what you were trying to explain.
Correct.
Just restate it, Bongani, because I think it's what you were explaining.
Okay, my understanding is that when the court or the courts are using the foreign law, they are using it to understand specific principles that are beyond the scope of the within the jurisdiction of that court. And that principle is amicus curiae, be it any form of that is brought into the court. But when in international law, where different treaties need to be understood on both sides of the law that are applicable on that matter.
Does that answer your question, Rhonda?
Can I
Can
can I
can
just add onto what Bongani said?
Okay.
I think in addition to that, if you look at international law basically is where we derive our Bill of Rights. So our Bill of Rights is basically taken from that. So internationally, we were influenced to have the Bill of Rights by international law. So which means that we may have to then consult that. I want to make an example of the International Court of Justice, because that deals with laws in foreign countries, but with necessary this part here says persuasive sources, so we can't really use it to come to decisions, but it can influence us to arrive at certain conclusions, or our judges can arrive certain conclusions by using that law. If I may just read page 107.
Yes.
It says that Section 39(1)(c) of the Bill of Rights states plainly that courts may take foreign law into account when they interpret provisions of the Bill of Rights. So I think that this is more so when they talk about Bill of Rights. I'm not sure if you would agree with me. So it says then, therefore, we can expect our courts to refer to foreign law more often when dealing with the Bill of Rights specifically.
Yeah, I have to agree. I think we must stay on that section 39(1)(c) of the Bill of Rights. It's a short part, but I think it's important to know the difference between foreign law and other legal systems. Okay.
Can I put it in another fashion?
Yes.
So you can say other legal systems would pertain to where we come from historically. Roman law, which then we got Roman Dutch law from that, but we know that there's Roman French law, there's Roman German law, etc., etc. But that would basically deal with a variety of subjects in law. Then foreign law, according to this textbook, limits us to when we deal with Bill of Rights specifically. So we then zoom in, not to take every subject in law, but we now zoom in and deal with the Bill of Rights. Then we're talking about foreign law in as far as Bill of Rights is concerned. I don't know if I've explained it properly.
No, I
Thank you. No,
understand it.
but I understood also.
I'm going to butcher this name. Tabatso. Please tell me I said it right. Tebatso. Your hands up. Okay, we're not getting a response. Okay, you have a question? Please ask your question.
So ma'am, I have a question.
Yes.
Since we are talking about the foreign law, I have a question here. How do South African courts apply foreign law when interpreting the provisions of the Bill of Rights in practice? Can you hear me?
Yes, I heard you.
Yes.
I'm trying to get words for it. How do we apply the
Foreign
provision?
law. How do South African courts apply foreign law when interpreting the provisions of the Bill of Rights in practice?
Okay, anyone want to help me on this one? Anyone? Are we all stumped now?
I think that, I don't know. I'll just try. I don't know the answer to your question, Tibatso, but all I can say is we're dealing with two sources. So persuasive law, rather persuasive authority is not binding. It's not binding upon our law.
Okay.
And the first one that we dealt with, the authoritative, it is binding. So authoritative sources, definitely binding, but the persuasive sources, it is not binding. Basically, it means that it's something that we can read and use to arrive at a particular decision. The judge can use it to arrive at a particular decision, but it cannot be used as law in our South African context.
Yeah.
Does that answer your question? Okay, Bongani, you want to add something? Bongani?
Yes, there's something that I want to read here from the Bill of Rights Handbook on page 52, how to interpret section 8.2 for the benefit of the person who asked the question. The Bill of Rights binds a private person in certain circumstances. According to section 8.2, the provision of Bill of Rights applies to the conduct of a private person or juristic person only to the extent that the provisions is applicable, taking into account in the nature of the right and the nature of the duty imposed by the right. So for the court to interpret, they will need to do the outlines on the Bill of Rights, and depending on the case that is being addressed, to what extent are they applying the Bill of Rights in those proceedings, because it's a persuasive law which only may be used to influence a certain reasoning, not a application of legal principles.
Okay. Okay.
Okay, do you understand that now?
Yes, I'm okay.
Okay. Is there anyone else with a question? Azande? We're on page 107 of the study guide, but that was in the Bill of Rights handbook, as Bongani is typing for you. Okay. Can you ask questions? Is there something on your mind, something you want to know from us?
Can I just, while we're still discussing, I notice that this learning unit is actually fairly short.
Yes.
It's fairly short. What you need to just do there is really go through those cases.
Yeah.
And it can be quite daunting because they look quite lengthy. But I think I'll probably come back to that later. But what I wanted to point out that comes out in this part is the hierarchy of courts. So these courts are hierarchical. There's magistrate courts, which is the district and regional. Then there's high courts, different high courts, and there's a Supreme Court of Appeal. And then lastly, there's a constitutional court. Now, any decision that is reached by a higher court is binding on the lower courts. And I thought that was quite important because it means that a lower court cannot arrive at a different decision than what a higher court has actually determined. And so it becomes then, binding. I thought I should just bring that up.
Bongani, you have a question or something to add?
No, it was the previous contribution I made.
Okay. All right. So, that goes on until 106. 107, sorry. We must be able to identify and explain different sources of law. Now, I don't know if they're going to do this because they said it's a quiz. So I think it's going to be multiple choice questions, all of it.
Yeah, all of it.
I'm just wondering if they say explain the use of different sources of law in scenarios. Will they give us a scenario and give us options what laws, sources of law we're going to use, or how would they ask that? I'm just wondering.
If you look at 109, I suspect page 109 of the study guide, those questions there, I think they will come in that fashion.
Yeah.
You see number 3 there, for instance, it says, which of the following sources of laws is the odd one out?
Yeah.
And then they say foreign law, legal textbook, articles in law journals, and case law. Already you can see which one is the odd one out if you read.
Yeah. Okay.
So which means that actually you've got to know your story, because if they ask this question in this fashion and you did not read, you will not know that, I think number 3, for instance, is the one that's, which one is it, number 3, that is out.
Yeah.
So I think that if we just make sure that we go through everything, because even number 2, if you see number 2, the decision of the High Court in Senegal versus Root, 1983-2, is binding on Supreme Court of Appeal, Magistrate Court, Constitutional Court, more than one of the above mentioned courts. So if you look at those 4, and you did not look at that case, for instance, because there's a case before that. So I suspect the reason they put those case studies there, they are probably just going to hoy in a question like that.
Yeah. I think that is where we'll have to read very carefully.
So I think that if you're going to not read it, if anyone is going to ignore those cases and not go through them, you're probably going to, I don't know. But I think that they help us to understand, they help us to understand exactly how the law is applied, at which court, etc., etc. Because they may thus hoy in a question like that, then you don't know where it belongs. So I think the reason they put so many case laws there is to help us to get familiar with actually reading cases and answering questions that are pertaining to them.
Yeah.
Ma'am, I'm sorry. Where is this guy reading from?
Page 109.
I said page
okay.
109.
Thank you. Thank you.
Portia, I see you lost. And Busi, I see you are all lost. Where can we help? What can we clarify?
No, I'm fine. It's a mistake. Typo.
Oh,
I'm good, ma'am. Thank you.
are you good? Okay. Okay. I will be. Okay.
Can I just share something? You see, when before I started Unit 6, it starts with that case of S versus Makwanyane, that landmark judgment of the Constitutional Court. I think we remember it. It was the very first judgment of the Constitutional Court back in 1995, I think, which was talking about the death penalty. If you look at that case, it is literally from page 86 right up until page 98. So that's about 11 pages, just reading one case. But what helped me as I read through, I then discovered that, oh, no. Here they have summarized judgments of each judge of the Constitutional Court. So if you actually go through it, then you will see that, okay, uh, somebody's got the mic on. Then you will see that, okay, Judge Chaskalson, who was the judge president, there is his judgment and what his view was on death penalty. Then it goes on and on. The deputy judge president, this is what he said. And it goes on and on. Then you go to page 92, Judge Ditscott, then Judge Kentrid, then Judge Klichera, Judge Langa, Pius Langa, Judge Madala, Judge Mohoro. So it goes on and on. And when you actually read the theme of their judgments, it was generally towards one direction: the right to life, right to dignity, right to humanity, etc., etc. Of course, they were explaining it in different ways, and each judge putting on their own, should I say, caveat in terms of what their view was on death penalty. Because remember, death penalty was not decided upon by Parliament at the time, because Parliament was supposed to have dealt with it, but Parliament deferred it to the Constitutional Court, so that the Constitutional Court can decide on that. So that first one, it could look very long, but quite frankly, if you could just look at it like that, know that, okay, this is the view of this judge, this is the view of this judge, you will notice that they have got many similarities. Also, they are claiming similar acts, section 11.2, section 8, section 9 and 10, and all of them are quoting the same. So it's basically easier when you look at it like that. I thought I should just maybe contribute that if anyone wants to look at that case law.
Tibatso?
I have a question here about foreign law. Does foreign law stands on its own, or does it have a meaning?
Could Devotee please repeat his question?
I mean, does foreign law stands on its own, or it does have a meaning?
Guys, can you hear me?
Yes.
It falls under the secondary, under persuasive sources of law.
Okay.
Does that help you?
I'm not sure if I understood his question. But I think
he wants to know if foreign law stands alone. Where I answered him, no, it falls under persuasive law.
Okay.
It's part of the sources of law, but it's the secondary one.
Yeah.
Persuasive.
Okay.
Yeah, it's not binding.
No.
Okay. Okay.
Rhonda, do you have a question?
Yes, ma'am. Oh, guys, I've got a question here. There's somewhere they said these cases, like we see the cases for Esma Kwanyane, the cases for termination of pregnancy, they said we don't have to go deeper into them, but they say there's a part when they say we must know the contents or we must know the feedback. Can we just go through over those, like the important things, not the whole case? I don't know. Can you hear the question I'm trying to drive home? Like they're saying there's some part of these cases that we must know for our exam. Do you understand what I'm saying, guys?
Yeah, I also
Okay.
did do something like that. But then with this, I feel like reading the entire thing helps you understand why they got to such a decision, even though we do need to understand the feedback and check what
The main
what the
points.
real issue was.
Azande, you have a question?
Yes, ma'am. Can you explain what is ratio descendant? Ratio descendant.
Ratio descendant.
It's ratio
Yes.
decidendi. Ratio decidendi. The rationale behind the decision. The reason for the decision. What are the reasons for the judge to come to that conclusion? That's the ratio decidendi.
Basically, he's saying it's a court decision.
The reason for that decision.
Okay, thank you.
Bongani?
Okay, I wanted to say ratio decision can be seen as the application of the authoritative sources of law and the persuasive sources of law in a court case by the judge. How the judge applied the law and what other cases persuaded him to reach that conclusion.
Yeah, Bongani is correct. Let me read that. I think she took this on page 103. If you look there at page 103, the second last paragraph, because remember, to get the law reports, because all cases and judgments must be lodged into the system in what is called the South African law reports. So in that publication, so they publish all the facts of the case that is concerned that you are looking for, the various arguments that the lawyers put before the court, and the reasons upon which the court based its decision. But here's where I want to come to. I'm just going to read it straight here. So when you go and look at those cases, it says when you read a reported court decision, you will never find a direct indication where the ratio decidendi or the reason for the decision. It says you are expected to find the ratio decidendi yourself, the reason for the decision for yourself. Now, it says this is often very difficult. In order to locate the reason for decision, you will have to be very familiar with the law and its applicable, and with the law that is applicable to a specific case. So effectively, what they're saying there is that you may not necessarily get every detail of what you want in terms of the reason for that decision, but you must be familiar with the law. Now, it comes back to what the other person was saying here later, to say that she wants the summary of what this case is about. You may have the summary, But if you have not read what the content of the case is, it's going to totally confuse you. So I think it's best to just read on the case. You don't have to cram it. You don't have to know it by heart. But I think you just have to go through it so that by the time you get to the conclusion, the verdict, you are able to say, oh, okay, no. The reason of this decision is because of 1, 2, 3, 4, what you have read on the content. I don't know if you can escape that, but that's my view. I don't think you can escape it. You've just gone to, I know it's a painful many pages, but guys, unfortunately, when you start practicing, you're going to have to read through documents and documents and documents. I know that, I know a number of lawyers and advocates. These people don't sleep. They are reading documents all the time. I mean, a person would tell you that I was reading the 200 and something page document. Another one would say, no, I had to go through 500 pages. So lawyers read. Lawyers read a lot. And I think that if we can just get to that mode as well, just right from the beginning, it will help us because they go through various, for instance, just one case law, looking for a particular, if you're representing your client, you're probably going to go through over 300 pages, 400, 500 pages. And that's the career that we chose, unfortunately. So I suppose that we're going to have to read.
Thank you. Thank you, in fact, for the encouragement. I didn't have time to read those paragraphs, but I think I have to go back to them again. Thanks again.
We have to. We don't have a choice.
Okay, all right.
Jabulani?
Good evening, everyone.
Hi.
Can someone help me with the difference between a legislation and a case law as a source of law?
Is there anyone who wants to jump in? I might just shoot myself in the foot, but legislation is the
Legislation and the difference between registration and legislation.
Yes, and a case law as a source of law.
I know legislation is the laws. It's just a fancy word for laws. If I'm correct, you can fix my broken law terms today. And then court cases is where you apply the legislation. Am I correct? Bongani, you wanna
Let me just put it simply, maybe. Let me put it simply. Legislation, okay. Parliament, you see these guys that we elect every 5 years, they go to parliament. Their main job there is to make law. So they're basically making law there. So parliamentarians, the different parties, they come together. Part of their responsibilities is to make law. So that's what is called legislate. So they legislate. So they basically make that. That's why legislation, statutes, acts of parliament all fall into one group. So they go there, they legislate the law. So it's the law that is being made. That's why in certain instances you hear that these are the lawmakers. So legislation is coming from that. Then case law comes from court decisions. So a case comes, it's X versus Y, the verdict comes. Once the verdict comes, it is lodged. All the other, so because it sets a precedence already. So anything that is pertaining to that particular, is similar to that particular case, we now go to that because it now has become law, which is case law. It is coming from a case that set and a verdict was given. Hence, because it's a case law. So that case set a precedent and therefore it became law. I don't know if I I explained it. In other words, they also call it judicial precedent because it set a precedent. I think Azande has also written something there. Yeah.
Okay, legislation is laws made by Parliament or other legislative bodies, while case law is law created by courts through decisions in specific cases. Legislation is broad and prospective. Case laws is more specific and retrospective. Do you agree? Bongani, I see your hands up.
Yes, I wanted to add something here on legislation. We can say the legislation laws that are passed by the parliament when there is a gap in the law, which is called lucanae, to fill that is that gap. Then a case law relates to the court decisions that were derived from similar cases by courts beyond or by the courts above the reasoning court. Meaning that if it's a magistrate's court, it will take a precedence from the High Court. If it is the High Court, it will take precedence from the Supreme Court, and the Supreme Court takes precedence from the Constitutional Court. So that's what I think we can add.
Jabulani, answer or add? Ask your question.
No, I'm answered, ma'am. Actually, what the answers that I'm getting from our fellow colleagues are exactly in collision with what I've written in my notes. I just wanna confirm because it seems to me that both the legislation and the case laws are authoritative. They are authoritative legal systems. But now with the case law, is it a primary or a secondary authoritative source?
There's no primary and secondary authoritative source. It's authoritative law. So case law is basically binding. Maybe let me use a different word. When you say authoritative sources of law, which means it's binding. So from anything legislation is binding. Case law is binding. Common law is binding. Custom law. So all of those five, they're binding. Then you've got persuasive. Persuasive is not binding.
Does that make sense, Jabulani?
I'm not answering your question. It's fine. I think somebody else will try.
Come, let's try and help Jabulani get to his answer. Okay, some of them want you to ask your question again. Jabulani, ask your question again so that they can understand what you want from them.
I just wanted to ascertain whether the case law falls under the primary or secondary source.
Do you guys get that? Zama, you must correct me if I'm wrong, but isn't that falling under authoritative sources?
Yeah, case law is authoritative. It's primary.
Okay. Does that answer your question now?
But before we continue, ma'am, I just want to ask Mr. Azande a question. I heard him saying there's no primary or secondary source. Can you elaborate on that if you can?
All right. You see, I was saying case law. You don't put case law under. You can't say case law is it primary or secondary, because case law is binding by its nature, so it cannot be secondary. It can only
Okay.
be. Sorry.
So I'm sorry to stop you. Before you continue, I just wanna refer you to page 107, where there's that case study of a note there, because that's actually where my question is deriving from.
Okay.
When you read there, it says sometimes authoritative and persuasive source of South African law may be referred to as primary or secondary source of law. And then it says Hambai et al. Describe primary and source of law as follows. Primary sources refer to law generated by the institution vested in law-making authority, for example, parliament and provincial legislatures, or to judgments of the courts. And then it continues to explain the secondary sources. So that's where my question derives from. We do have the primary and the secondary. I think what this explains is that in primary sources, okay, just in general, both the primary and secondary sources, they give us the level of importance of each source. Meaning, from my question, I have an understanding that between the two, a legislation and a case law, there's one source that is important than the other. I don't know if I make sense.
Yeah, you're making sense. What you read here, I think it's what I was not able to explain it. If you read that first sentence that you read, sometimes authoritative and persuasive sources in South African law may be referred to as primary and secondary sources. So that sentence is basically what I was saying earlier. So authoritative is primary, persuasive is secondary.
No, Mr.
So
Zuma, you're mistaking it. It doesn't say primary and, it says primary or, meaning you can only take one stance there.
okay, I don't understand it like that. I understand it differently.
So your understanding is that we cannot differentiate the level of importance in the sources.
For instance, if you read that last sentence, it says secondary sources of law essentially provide further information on primary sources of law.
Hence, I'm saying that isn't there a possibility that a primary source can have detailed information than the secondary source, which then the secondary source can further explain what is being explained in the primary source?
I'm not sure of what you're saying, because what I gather is that the primary source of law, which is the authoritative source, is the one that's binding. Do we agree on that part?
Can you repeat that statement again?
I'm saying the authoritative source is the primary source and is binding. Correct?
There, I agree with you.
Okay. Now, the persuasive law is secondary, meaning it is not binding. It is there to explain and further elucidate what is meant. You don't agree?
For now, I don't have a stance. I think we can just park it and discuss it later because I really need clarification on this. But also, with the first answer that you gave me, I'm now hesitant of,
Okay, maybe
because when you
somebody else
said
can come then.
there is no, when you said there is no primary or or secondary source.
What I was
and
just
then
trying to say,
that
but it means the same thing.
It can't, Mr. Zama.
Okay, no, then somebody else can come in then.
Bongani, can you enlighten us?
Yes. How can I put it? We look into legislation as the form of authoritative law in any aspect, be it governing the community or governing the community in their behavior. So these legislations define the acts that are prohibited in the society, be it theft, murder, and any form of misconduct. Then, unless it is given a specific example, that which is the secondary source that will be used to enlighten what the legislation is saying. So whatever form of secondary source that you may take or your persuasive source that you may take, it may not be binding. I'm going to try and call me.
Bongani? Bongani?
Bongani?
Oh.
I think he muted his mic by mistake.
Hello.
Bongani?
Yes.
Bongani?
Hello.
Yes.
Yes.
What I was saying is that the legislation is the primary source of law in the sense that it prescribes the condemned behavior within the society. Unless a specific example is given, we need to understand which persuasive source is used to enlighten or to add weight onto what the legislation is saying or what the legislation is condemning. We look, for example, we have our Criminal Procedure Act that defines all the criminal elements that the law forbids. If Mr. Bongani is he committed a crime, and that crime is similar to a crime that was committed by Mr. X maybe 3 years ago, the same law that we used to convict Mr. X will be applied because of the similarities of the case. That's where the case law is applied, but it adds weight on what the legislation is condemned or what the legislation is promoting.
Jabulani, does that give you more insight?
I'm not sure if I'm following, ma'am.
It's not what Jabulani was asking. But what Bongani is saying is correct, but I don't think it's the actual question.
Yeah, it's not answering the question. I'm gonna butcher this name. Yes, your hands up. I'm not gonna pronounce this name. Shame he or she's gonna hate me.
Yeah, it's okay. It's okay.
I think the first thing this speaker must tell us your name, ma'am.
My name is Morphe.
Morphe.
Yes.
Okay.
And the surname?
Mpapuri.
Oh no.
Okay,
you were saying?
I think what Wongani was asking, he wanted to know which one was primary source and which one was secondary source between legislation and case law, which we can't say because both of them fall under authoritative sources, meaning both of them are primary sources. I'm not sure if he understands.
You're 100% correct.
Okay, does that
Yes.
make more sense?
If that's the case, it does. It does.
Okay.
And I do want to agree with Mr. Zama when he said the primary sources can be the authoritative and the secondary can be the persuasive. I just confirmed that I got it. Thank you.
Okay. Is there someone else who has a question? Zama, you can jump in.
I don't have a question.
Okay.
I think as far as I can see, unless there are questions, I think we're done with this. I think the rest is activities, I think, which we can do in our spaces, do those activities, and then read those case laws. Otherwise, I think this chapter is done.
Yeah, I'm also sure. Because I'm just checking here that Nordia and other versus Fraser is also one we must just read through very carefully. They might not ask us the whole case, but they might just reference to it, or you must just maybe know what the outcome was. If I'm not, because that's what I did with mine. I went and I read through the whole case and then just made summaries to my own, just to say this is what case it is, this was the judge, this was the end result, things like that. That's what I found worked for me. Yes, Rhonda.
There's a question there on the chat.
Okay, since foreign law and modern legal, does persuasive sources become authoritative for future cases? Sorry. Do you think persuasive source can become authoritative source for future cases? Now I'm gonna. I think. Yes.
I think even if we have to use the possessive law, they will remain like that. That's what I think. They will remain like secondary sources, while it will still remain with our primary ones. I didn't understand also the exact question.
I'm not sure persuasive can become authoritative. Or am I?
What should have happened for them?
I think it can, so long as the court applies it in its judgment at some point.
Okay.
Or when the constitution will make it like binding. Only that.
Yeah.
I think.
Yes.
Can I? I don't know. I think we may put ourselves in a corner here.
Yeah.
I think we may put ourselves in a corner here. I want to use the word that they use here, persuasive. You see, when you are trying to persuade somebody, you make examples. You are trying to persuade this person. So you make certain examples, but they are not pertaining to exactly what you're talking about. So they're not the content of your subject. I want to make an example, for instance, on that case law, the very first one, S versus Makwanyana. The last judge there, Judge Sachs, on page 98, just as an example, he mentions in his judgment, it talks about the positions that are adopted by the framers of the Mozambican and Namibian constitutions, which were based on bending the knee to foreign ideas, but rather on memories of massacres and martyrdom in their own countries. So you see, he goes out of our law to actually quote certain things in his judgment, trying to persuade the outcome of the case by taking out examples from foreign law, because this basically was quoting from foreign law. So I think it's a case like that. You can correct me if I'm wrong, but I do not think that you can have a persuasive law becoming authoritative, and only unless it is legislated. Once it becomes part of legislation, then it is authoritative. But if it's not part of legislation, or our case law specifically, I don't think so. Unless I'm not getting it right, but I don't think so at all.
Yeah, I have to agree with you. I don't think it can. Andani?
Okay. Yes. I will have to agree with Zama because of the ideas and explanations of foreign law and modern legal writers are often used by judges to understand to or interpret complex legal issues. So the views of foreign law and modern legal writers can influence the development of the law, but they do not have the force of binding authority like legislation or court decisions. I think Zama has made it quite clear.
Yes, I have to agree with you guys. Rhonda, do you have a question for us? Are you happy? Okay. Now I'm going to call on Zama for... Yes, Jabulani, before I go to Zama.
Gosh. You can, ma'am. I just want to raise something from our previous meeting. You know actually about it. I just want to caution Mr. Bongani about it.
Yes.
Should I go on before you go to
Yes,
Mr.
go on.
Mr. Bongani, do you remember the little debate we had last time about the what was it? Can I quickly refer? I'm gonna come back right now.
Okay. I need you guys to explain these Latin words. I'm not going to try and pronounce them. Ask the other ones. I'm butchering the poor Latin language. Let me just get it where they use it. It is that ratio descendini, something like that. What is that? I am pronouncing it incorrect. Can someone please help us with that?
Sorry, which page is that? Are you talking about the ratio decidendi?
Yes.
The ratio decidendi.
Yes.
Yes.
Someone wants to know what the meaning is, or what does it entail?
Okay. Page 103. It says ratio decidendi. A literal translation of ratio decidendi means the reasons for the decision. So when you read a reported court decision, you will have to find the reason for that decision.
Okay.
Yeah, Azande is writing something there. The underlying principle that determines the outcome of the case is a binding part of the judicial decision. So yeah, so this basically, in simple terms, he is correct, Azande. I was just putting in simple terms. What was the rationale behind this decision?
Okay.
And then the more legal way to put it is what Azande has put there.
Okay. I hope you all see what that's written there. Okay. Then can someone explain What on earth? Oh, Bubbles, you've got a question? Bubbles.
Yes, everybody. Am I audible?
Yes.
I just wanted to go back to the question that was raised. The persuasive source, whatever, can persuasive source become an authoritative for future cases? The answer is no.
Okay.
Was the answer no?
Yes.
I went on and did some little digging in that time that I was given, and I have something to read for you guys. In the meantime, can I?
Yes.
So here in the this is not my idea, by the way. It's Google. It says the question was, can a persuasive source become authoritative? And it says yes, but it has a but indirectly. So a judge will apply persuasive reasoning to decide a case. Court's decision creates a precedent in South Africa. The ratio decidendi, which is the legal principle for the decision, is now binding on lower courts. So the persuasive court influenced the law, and the new South African court decision becomes an authoritative source. So the persuasive source itself never becomes binding, but the decision it inspires does. So persuasive sources guide decisions when South African law is silent. Once a South African court uses it in a ruling, the court's decision becomes authoritative for future cases. I don't know if that explains it well.
I don't think
Yeah.
I don't think it disagrees, Bubbles.
It does not.
Not according to what I
Even
was looking.
sorry.
The excerpt that you read, I don't think it's necessarily in sharp contrast, because it says, if I heard you well, that the decision itself is binding, although they used persuasive sources. So the persuasive sources, yes, we used to arrive at a decision. So that decision itself, the ratio decidandi, reasons to get to that decision, will then remain in records and may be used also for persuasion. But
so the
so
fact that they said they like added a but to say but indirectly, so it still stands with your answer.
yes, because you can still use those even in future instances. You can still use that in case X and stuff like that when you're quoting case law, and you can use same persuasion to persuade in the current case. It does not take it to authoritative source, though. I think that, as I said earlier, it becomes authoritative once it becomes part of the authoritative sources of law, which is either by legislation or by a court cases or common law. Because all we are given is that authoritative sources are 5: legislation, court decisions, common law, custom, and indigenous law. That's all we have. Nothing beyond that. So if those persuasions are then legislated, then only it can be part of authoritative. If it's not legislated, it can't be. It remains persuasive until such time that it is legislated, in my view.
Okay. Thank you.
Okay, Azande has a question for us. Oh my gosh. Jabulani, before we get to that question, Jabulani, you want to ask something?
No, we can continue, ma'am, because this one is taking us to what we've dealt with.
Okay. Can someone explain obiter dictum Obiter dictum. Am I pronouncing it correct? I don't think so.
Yeah, you're correct.
Oh, wow. They want to know what is it. I think it's on page 104 at the top.
I think I saw somebody answering it on the group on the chats there. I just can't find it anymore. But somebody just answered it so well. Was it Bongani? I'm not sure, but somebody answered it so well there.
Okay, yeah, it is. Refers. It's Azande that made it common.
Yes.
There's written. It refers to comments made by a judge that aren't. There goes my answer. Oh my word! Now I need to find my answer. Okay. It refers to the judgment. It is reference to the comments made by a judge aren't essential to the decision. They are not binding, but can be persuasive. So it's written here. It refers to the comments made by a judge that aren't essential to the decision, but they are not binding, but can be persuasive. Wants to find out if they are correct or not. Bubbles, do you have a question or an answer for me? Bubbles? Is that an old hand?
Old hand.
Okay.
Colleagues, I'm sorry, man. I'm going to have to, unfortunately, step out of the meeting. I think, man, my night is very short and I need to get through some of these case laws. But thank you so much for the class tonight. I still need to prepare for work as well tomorrow. So, unfortunately, I can't stay much.
Okay. Thank you.
Thank you. Bye-bye.
Yeah, thank you. You were very useful, Shem.
Thank you.
Thank you. Bye-bye, guys.
Yeah, don't miss us tomorrow. Next time.
Bye.
Bye-bye.
But guys, are we not done? Or we are almost?
We're almost done.
Okay.
So we answered half of the question. Now, the other one was, now I have to go back. The principle of judicial present. Does anyone have an explanation for that? Bubbles? Kapane?
Sorry, ma'am, I forgot to mute myself. I'm sorry.
Okay. Okay, yes, it means lower courts are bound by decisions of higher superior courts. Okay. Did you get that? Does the foreign law and the Bill of Rights interact? Bongani, maybe you can help here.
Yes, it does interact. Yeah, just try to read through the subtopics here of the headings of the Bill of Rights and see what I can get. But they do interact. Let me start with we can look at maybe the structure of Bill of Rights litigation, application of Bill of Rights, justiciability, jurisdiction and procedures in Bill of Rights litigation, interpretation of the Bill of Rights, limitation of rights, remedies, equality, human dignity, life, freedom, security of a person, slavery, servitude, forced labor, privacy, religion, belief and opinion, expression, assembly, association, political rights, citizenship, freedom of movement and residence, freedom of trade, occupation and profession, labor relations. These are just subheadings under a Bill of Rights. Environment, property, socio-economic rights, children, culture, yeah, things like that. Access to courts, arrest, detained, and accused persons' rights, state of emergency. These are the subtopics contained within the Bill of Rights.
Okay, is there any other questions before we call it a day? Anyone with a question? Are you all comfortable with Unit 6? Okay. I am going to set a poll again to see when we're meeting up again. Oh, Katleho.
Hello, ma'am. How are you?
Fine, and you?
I'm good, thanks. So, where can I get the recordings for the previous learning units? Because I've been missing the class, you know.
Some are on the group and some are on YouTube. I think Unit 5 and Unit 6 will be on YouTube because it's quite lengthy. And I think we started only with Unit 4 recording. I think that's back in the group. I'll see if I can find it, I'll just repost it for you guys. Are you on the group?
Which group can I ask?
The ILW. Where did you get the link for this meeting?
On WhatsApp.
Okay.
Hello.
Yes.
Yes, I'm saying on WhatsApp, ma'am.
On WhatsApp.
Yes.
Okay. There's my number on the screen.
Okay.
You guys can just WhatsApp me your name and then I'll add you as we go along. Then I'll
okay. Thank you.
Because all the notes I have is also on the group. I reposted those Unit 6 ones. I can resend them again, and then I'll resend 1 to 5 as well. And then I'll post 7 as well because we're going on to 7 later this week. Yes, Rhonda. Rhonda, what is?
Okay, guys. Hi again. So I wanted to ask guys. I think maybe you mentioned in the last lecture that our assignment 1 covers from Unit 1 to 6. Is it?
Yes.
Now that we have come to the end of Unit 6, colleagues, I was just assuming or suggesting that we start going through the past exam questions, like those multiple choice ones, and until we are complete with the first assignment, and then we continue on the second half. I don't know, that's my suggestion.
What do you guys think? I'm just not sure that maybe they will ask the same questions. If you guys have question papers, then add it on the group so that we all can go through it eventually. Okay. So if
are you guys okay with that, or we must just continue from Unit 7 the next time we meet? That's what I was asking, ma'am.
Yeah, I can't make that a decision on my own. That's why I'm asking everyone to give their input. What do you guys think?
I don't see a problem.
Azande?
I don't see a problem.
Okay. Katleho, I see your hands up.
Ma'am,
Yes.
can't we have if we decide on taking that route, can't we have two sessions per se? I mean, two separate sessions per day, because if I look at the email that they sent today, the opening date of assessment 2 is already out, and it's almost consecutive date that follows assessment 1. So we do need to push the units from 7 to 12.
Okay.
Yeah.
Yeah, I haven't looked into my emails yet, so
Yeah, so if they didn't space, they didn't give us time between assignment 1 and assignment 2, so it could be we're in trouble then.
Yeah, because the opening date of assignment 1 is on the 23rd and it closes on the 8th April. And then assignment 2 opens on the 7th of April and it closes on 21 April. So we yeah, it's just next to each other.
Yeah, next door neighbors.
I think we must just steam ahead. If there's any questions on that you guys are struggling with, you can always bring it to the group and we can discuss it. If you're having trouble, then otherwise we are not gonna get
Or
through this.
else let's schedule questions for Sundays, guys. Guys, are you busy on Sundays or will you be drinking? I think Sunday's okay. With me, Sunday's okay. Then you said Sundays for revisions only.
Hi, weekends are out, guys.
Guys.
Maybe for some of us. For some of us. Weekends, we go to church, we do this, we do that, we run errands, we have kids. They go to sports and everything.
Even in the evening.
Maybe in the evening, but not in the mornings. It doesn't work out.
Obviously, in the
And
morning
during
we
the day.
go to church and do some things. I was asking maybe in the evening or any other day that we can set aside only for past exam questions. That's what I wanted to say, to be precise.
I think, guys, let's just put up options that we can all weigh and then create a poll on WhatsApp to vote on.
Would it be possible for the question papers to just be posted on WhatsApp while we continue with the sessions?
I will try and get them all. But if someone else has a copy and you can send it on the group, by all means, please share. And I'll share as much as I can find.
Okay, thank you.
Atlejo, you have a question or something you want to say?
Yes, I was saying that whatever that the decision that you guys may come up with, like just consider us, some of us, because some of us are working, I don't know how many of y'all are working, so just know that there are people who are working, man. So whatever that you guys may come up with, just consider, other people.
Hence, I'm saying, guys, to be fair, let's just put our options up front and then create a poll where we all vote, just to be fair, because even if we put excuses of people working or others taking care of their kids, it wouldn't be fair if the majority rules that we should have sessions on weekend. And plus, we have these sessions recorded. So if one cannot attend on the agreement date that we said, they can always refer back to the recordings.
Yeah. Yes.
Well, guys, Mina, my suggestions is always after hours, whatever the day or what, but it should be always after hours. I'm also working.
Yeah, that's why we do it like 7 to 9.
Yeah.
I don't want to keep you until midnight. But if you guys are having trouble with 7 to 9, then it'll have to be 8 till 10. Because we can't stretch later than that. We all have busy schedules in the morning, and yeah. So I'm going to put it up in the group. I will add the rest now, and then I'll repost everything. So yeah, I will add you first, and then I'll repost the focus areas as well as focus areas 7. And when I'm done with that, I can put the meeting on YouTube for you guys. Okay. Is there anything else, guys?
Thank you.
Jabulani?
Yes, ma'am. I pertinently want to talk to Mr. Bongani, Azande, and Brianna. Can they just confirm if they are on the line?
Bongani is here. Azande is here.
Yes, I mean.
Yes,
Brianna's
guys.
also here.
Yeah, do you remember last time when we were talking about Unit 5 and I had a question on the rules that are given to the investigators as to, I mean, they are obliged to follow those rules when gathering evidence. Yes, and then you guys said that it depends with the case. It can be civil or procedural. You remember?
Do you guys recall that?
I don't remember.
I recall. Maybe Mr. Chablan can go ahead and give us the details.
Yes, well, I've done some few diggings, guys, and according to the results that I've got, that answer is it cannot be used. It's not safe to use it because remember, under the definition that we have of what civil law is, we are saying that it's a regulation between the private individuals. And like I was trying to say last time that if we include the investigations in the case, that is merely to be dealt with by the state and not the other way around, meaning it has nothing to do with the civil law, like I was saying. Because, okay, I'm just gonna read from what I have here. Civil law can, I mean, investigators cannot be put under civil law because this is between two individuals or juristic persons. And because this is between two individuals, it can be applicant or respondent. And these parties, they bring their applications to the court. These applications must prove the evidence according to the balance of proportions that are brought before the court, meaning these applications that are brought before the court are brought either by the applicant or the respondent, not the investigations, like I was saying previously. So when these applicant or respondent have brought their cases before the court, then it's up to the litigants to argue the case, like I was saying. But when it comes to the investigations, that is the work of the state, because the criminal procedure would be the one that stipulates the rules of how to gather that evidence. And when the investigators have gathered that investigation, they bring it to the prosecutors or the NPA to further now bring the evidence to court. Even at that stage, they use the rules stipulated by the law of evidence. So in essence, what I just wanted to raise, guys, is that civil law, under that question that I posed previously, it's not safe to use. You can
Hello.
comment if you wish to.
Yes. I think you could have allowed us to research further to substantiate our reasoning. Because if you remember very well, I said if there is no case to use as a template, it will be difficult to understand what level of application are you referring to by the investigation. And I gave an example that you want to claim money from Mr. Bongani. You go to small claims court, you write a letter of demand as a procedure, which the respondent has to sign and acknowledge the debt. So I gave an example that on criminal procedure, it is based on the presumption that the accused person is innocent until that person is proven guilty beyond reasonable doubt. So my argument is that unless the court is in unless the case is enrolled in courts, any investigation that are done do not fall under evidence, but they are guided by the criminal procedure. Be it a statement from the witness, it's not evidence by then unless it is presented to court. It's just a statement, a sworn statement by the witness A. It's an exhibit 1, 2, 3, unless it is presented before the court. That's where it becomes evidence. But when it is gathered, it falls under a criminal procedure. To what extent? I gave an example that, let's say the statement that is needed is from a minor rape victim. There is a procedure to acquire that statement before it is being used in court as evidence. I'm not sure if I lost you today, Mr. Jabulani.
No, not at all. I just feel like you're just issuing out a prejudgment when you're saying I didn't give you guys a chance to research about this, because it was just a general question that aroused from the lesson. I just wanted to avail that information to you guys that civil law has nothing to do with the investigation. You even said on the last meeting that it could be a vocabulary problem that we have mina nawe. So I'm saying that I'm trying to fix that today, that it's not a matter of vocabulary. It's just two different things that belong to two different worlds. Civil world is another world. Criminal procedure is another world. And even as far as the investigations are concerned, they don't get related into the civil law, because even when the applicant and the respondent are bringing their cases in court, at that stage already that is evident that they have personally. So when the litigants receive that information, to my understanding, when they argue those evidence, they use the law of evidence to further argue their case. So still, it doesn't. I don't know if I make sense.
Mr. Jabulani, my argument will be different. because it will say some civil matters are sent for mediation, like the CCMA, either is corrupt or not. That's a civil matter and is sent for mediation without a court trial. So there are certain remedies on civil matters that may opt out of a court settlement. But on criminal matters, the state is the one that charges you for infringing its laws or is infringing the rights of another citizen. So the remedies of dealing with civil laws can vary from being a court procedure and an out of court settlement. But criminal cases all remain to be prosecuted by the state.
But what I'm saying still is that even at that inquiry, no investigations are, no investigators are to be used, because that's the work of public law, if I'm not mistaken.
Yes, that's the field of criminal procedure, according to my defense. That's the field of criminal procedure. Either the investigators are there to get a sworn statement, a photograph, or fingerprint, or whatever. Your pings, your phone location. They are done to prove your role in a crime. Then when it is a matter, a civil matter between the applicant and the applicant is the one who is making an application to the court for a remedy against the respondent, saying, I've Mr. Bongani, who is owing me XYZ amount. And what are the remedies that I'm supposed to use to reclaim this money? I'm still using the small claims court, where you do your letter of demand, you get an escort to my premise, and I acknowledge the accurateness, the authenticity of the claims laid against me. So by signing that letter of demand, I'm acknowledging that I have got a civil matter with Mr. Jabulan. But when it's a criminal case, I use the presumption that the accused person is treated as an innocent accused person,
until
proven
guilty.
beyond reasonable doubt. And whatever investigation that is done is merely to satisfy that the guiltiness is proven beyond reasonable doubt, be it by presenting a sworn statement as evidence, photography as evidence, an alibi as evidence. Whatever is being presented is to satisfy the requirement that has to be, the accused person has to be proven beyond reasonable doubt.
No, well, if that's the case, I think we are on the same page.
No problem, Mr. Chablanin. I value your contribution towards that heated argument.
No worries, no worries. Rihanna, any comment? Oh, okay, no problem.
Ma'am, where are you? Where are you, ma'am? I think we must call it a night. Thank you, bye.
No.
No, good night, guys.
Good night. I think we must meet a day after, not tomorrow, right?
Yes, let's take a break tomorrow, please.
Yes. And in fact, tomorrow we are doing something on other modules, guys. Until then, take care.
Bye.
Bye.
Bye, ma'am.
Bye, guys.
Bye, ma'am. And good night.
Thank you. Have a wonderful night.
Same to you.
Bye.
Morphe, I see your hands up. Did you want to ask us something before everyone decided they're going?
Ma'am, everyone they
Yeah, there's a hand still, and
ma'am, everyone they said good night, bye. Nobody's Hey ma'am.
Yes.
Everyone they said good night, bye. Let's call it a day. I don't know if anyone has still attended.
There's still a few, but they're not answering, because I see there's a hand and everyone left before they answered. Azande, can you pronounce her name?
Azande.
No, that's your name. The hand that, can you see whose hand is up?
Mufere can pronounce
Mpapuli. Mpapuli. I think that's your surname. I see your hands up. Do you still want to ask something? Okay, no, she's gone. That's probably an old hand. Okay.